video, I'm back with another edition of Delay Tactics in Florida Family Court and how to combat them. For today's purposes, we're going to assume you've successfully served the other party and they've filed a timely response. So after service is complete and all pleadings have been filed, the next step in a family case is called discovery. Discovery, generally, is the exchange of evidence in a court proceeding. Due process, which I also discussed in my last video, requires all parties to have notice of all evidence that will be used by the other party in court. The other policy working behind discovery here is that in order to make any financial decisions about things like equitable distribution or child support, whether it be between the parties in negotiations or by the court at trial, there needs to be full transparency. In theory, that means no one should be able to hide assets or income from the other party because they would be required to disclose those documents in discovery. In Florida family courts, the process of discovery starts with what's called mandatory disclosures. Mandatory disclosures are the baseline financial documents both parties have to provide to each other before mediation. It includes things like pay stubs or other records of income, tax returns, banking and credit card statements, loan applications, etc. Every type of disclosure has a different time frame you are required to disclose for. For example, you have to disclose the last 12 months of bank statements, but only 6 months of pay stubs. It's all listed out in the Pro Se Certificate of Compliance form. You can just Google Florida Supreme Court approved family law forms and then navigate to the flcourts.gov website, which has a ton of fillable family law forms for people who don't have attorneys. You are not supposed to file any of the disclosures except the financial affidavit. You just give the documents to the other party. The only other thing you need to file for this is a certificate of compliance. The deadline for mandatory disclosures is 45 days after the date of service. What do you do if the other party is delaying discovery? The first thing you have to do is comply yourself. You cannot enforce a rule against the other party if you are not also in compliance with that rule. Step 1, if you want the other party's mandatory disclosures, provide yours and file your certificate of compliance. After you've complied and the 45-day deadline has passed, you can file a motion to compel mandatory disclosures from the other side. You can also file this if they've only partially complied. For example, or at least have some good faith reason to suspect that they're holding out on giving you certain documents or financial information. Once you file the motion to compel, the other party can either comply and give you the documents or wait for a hearing on the motion. If the name of their game is delay, they will likely wait for a hearing. Sometimes they will comply the night before the hearing, or I've even seen things sent right before the hearing or as I was walking into the hearing itself. Sometimes they will even wait for the court to order them to comply after the hearing because it buys more time. These are the types of situations in which it might make sense to ask for attorney's fees and costs. There are other things you need to prove for attorney's fees and costs, but that's for another video. One note on fees and costs, pro se litigants can also ask for them. You don't actually have to be represented by an attorney. If you filed a motion to compel, it's been granted, and they still haven't complied, then your option is to file a motion for contempt and enforcement. And if you didn't ask for attorney's fees and costs in your motion to compel, you definitely want to ask for it in this motion for civil contempt and enforcement. For civil contempt, the movant, or the party who filed the motion, has the burden of proving that the other side willfully violated a court order or rule that they had the present ability to comply with. I think the bottom line here is that there are ways to try to push back against delay tactics, and the courts are moving towards speedier timeframes for trials and procedures. But for the time being, you really should be prepared for things to take longer than you would like them to. There are enforcement mechanisms to combat delay tactics, but usually they involve filing a motion, which then requires a hearing. And all of that takes even more time. The important things are to be in compliance yourself and try not to have the attitude of, well, if they don't have to do it, why do I? Because that makes enforcement basically impossible. And it also can make you look just as bad as the other party, at least in the court's eyes, right? It is always better to choose the high road in a family case, follow the rules, do what you're supposed to do, regardless of what the other party is doing. And then it is much easier for the judge to see who's really causing the problems here. Hope this helps. Good luck with your family cases. And as always, stay safe out there.